Yes.
Good morning, everyone. Welcome to panel 12 on this second day of the SIEL conference on rethinking global economic governance. My name is Dan Hohnstein. I am an editor of TradeLawGuide, which is one of the sponsors of the conference. I am also a partner at Taraposky and DeRose, a boutique law firm specializing in trade and investor state dispute settlement resolution. It is my privilege to serve as your moderator for this roundtable discussion on investment law and climate change. This roundtable will feature the perspectives of our esteemed colleagues, Helen Pang, a PhD candidate from the Faculty of Law at the University of New South Wales in Australia, Professor Ying from the China Law School of Renmin University, and Dr. Rosmy Joan from the Faculty of India's National Law University, Jodhpur. I would like to remind you that this roundtable is being recorded, and the recording will be available on the SIEL conference platform for all registered delegates. In terms of the agenda, I would like to start by introducing the theme and the panelists to you. The panelists will then present their perspectives in a brief talk of about 10 minutes each. They will then engage in a discussion and perhaps some friendly debate for about 15 minutes before we open the floor to questions from everyone. Throughout the roundtable, we encourage you to use the public chat function to provide comments or questions. The panelists are free to respond to these at any time. If appropriate, I may direct certain points to the panelists for their views. In addition, and perhaps out of an overabundance of courage, we are also going to activate the option that allows audience members to appear by video conference to provide comments or ask questions if you wish. This is entirely optional. It's also a brand new feature for everyone here, so we'll see how well it works. For those of you just joining, the theme of this roundtable is investment law and climate change. The fact of climate change is becoming increasingly evident. Just last week, there were all-time high record-breaking temperatures across the normally temperate west coast of North America. On a Celsius basis, temperatures ranged into the mid to high 40s for regions that are normally in the high 20s to low 30s. Over the last couple of years, unusually hot and dry conditions have had profound adverse impacts, from severe wildfires in Australia and North America to drought affecting agricultural production in Central Europe. Climate change is certainly bringing with it tremendous challenges to the global economy. And the other side of that coin is the tremendous economic opportunities that are emerging in terms of industrial solutions to climate change, such as green technologies. In this context, the intersections between environmental laws, including those implementing environmental agreements, and existing international trade and investment obligations are becoming increasingly important. This is why today's discussion and the broader academic discourse on this topic are genuinely important. We have three experts in that discourse with us here today. Our first panelist is Helen Pang, who will be presenting her perspectives on the public interest challenge arising in relation to climate change in investor-state dispute settlement. Hui is a PhD scholar at the Law Faculty of the University of New South Wales in Australia. She currently focuses on investor-state dispute settlement in the renewable energy sector. Her thesis examines the rights and responsibilities of investors and the state in renewable energy investment cases, with particular regard to international environmental obligations. Before joining the UNSW Law faculty, Hui was a Fox Fellow at Yale University and researched sustainable development in international investment law from the perspective of developing countries. Hui has published book chapters, policy briefs, and articles in English and Chinese. And she also has experience in private practice, including on mergers and acquisitions and international securities. Our second panelist is Professor Ying. She will be discussing her views on the structural tensions between international investment law and environmental law. Professor Zhu is a professor at the China Law School of Renmin University, where she is also the Deputy Secretary General of the Institute of International Commercial Dispute Prevention and Settlement. She is a graduate of Yale Law School and also the China University of Political Science and Law. Her doctoral dissertation, which was on the topic she will be addressing today, was awarded the Yale Law School's William T. Ketchum Jr. Prize for Best Student Paper in the field of private international law. She was a senior assistant to the president of the International Union for Conservation of Nature, and she has served as a member of the Chinese government's delegation to the UNCITRAL Working Group on Investor-State Dispute Settlement Reform. Our third panelist is Dr. Rosmy Joan, who will be discussing concerns about the governance of international investments in natural resources from a developing country perspective. Dr. Joan specializes in international economic laws and public law at the National Law University, Jodhpur. She is a graduate of the Mahatma Gandhi University, the O.P. Jindal Global University, and the National Law University, Jodhpur, where she earned her doctoral degree in international investment law and policy. Dr. Joan has won many academic awards and accolades and holds leadership positions, including as the executive director of the Center for Studies in Law and Policy concerning environment, energy, and natural resources. With that, I would like to welcome Helen Pang to the stage. Over to you.
Thank you so much. It's a privilege to be here today. My topic is on adjudicating climate change through renewable energy investment, the public interest challenge, investor-state dispute settlement. So before I go on to the legal inquiries, I would like to kind of talk a little about why I'm focusing on renewable energy foreign investment. Well, first, I came across a set of figures that really surprised me in 2017. Back then, the International Energy Agency released their report and said that 400 billion subsidies, 400 billion US dollars in subsidies were provided globally to fossil fuel investors back in 2017. And 115 countries still subsidize fossil fuels, out of which 73 countries provide more than 100 million US dollars per year. So with those figures in mind, I was thinking, how could we transit into a clean energy society when we're still heavily subsidizing fossil fuel investment, and states can still backtrack from their previous incentives granted to renewable energy investors? Take this Spanish case, for example. During the first decade of the 2000s, they were heavily subsidizing and providing many incentives to renewable energy investors. However, due to 2008 financial crisis and also some political change in their government, they decided to backtrack from their previous incentives granted to renewable energy investors. And with that in mind, that has incurred many investor-state arbitration against Spain in the past few years. And against this background, I was thinking, doesn't the state own certain kind of obligation to the investor beyond the BIT itself? Could we connect the obligation of states to mitigate climate change to the legitimate expectations of the investor for support to clean energy transition through the BIT? Is there such a connection? And could this platform be a kind of unorthodox platform to climate change mitigation? So that is the general background of my research. And I have two major legal inquiries based on the paper I'm presenting today. The first legal inquiry is the role of international environmental agreements, investor-state arbitration. I looked at cases from S.D. Myers and the case of S.D. Myers versus Canada, Allen versus Barbados, and the counterclaims made by Ecuador, and also the right to water argument made by Argentina in the Ubasa case. And I realized that from the S.D. Myers to the Allen versus Barbados, the tribunal hasn't really closed its doors on the jurisdiction issue for the application of international environment agreement. For example, in S.D. Myers, it didn't say that the Basel Convention was not applicable. It simply stated that because the US hasn't ratified the Basel Convention, it is not applicable in this case. And it even further provided analysis saying that if it was applicable, it would not be applied in this case because the least restrictive trade measure should apply. Back then, the tribunal was taking a more co-optive approach to environmental protection concerns. However, if we look at how the tribunal has developed in recent years, we would see that through the counterclaims presented by Ecuador, and also in the Urbosa case, Argentina also raised the arguments of the human rights upfront approach, stating that even though they haven't really restricted private parties under international environmental agreements, the tribunal has came to the conclusion that certain obligations and a general obligation to protect the environment in the host state is and should be borne by the investor. So I think there is a general approach in international investment law that is moving towards sustainable development. And if we look at how institutional reactions are reacting to this change, we could see that the ICC has set up a panel in 2017 investigating how it should reform arbitration rules to react to climate change related disputes. And also the Stockholm Chamber of Commerce organizes panels and conferences and discussions on how to structure a model treaty that would combine climate change mitigation objectives with investor-state arbitration. So and also the World Bank released an agenda from 2016 to 2020, stressing that there is a need to implement climate change mitigation policies within the World Bank group. So I think there's a general consensus and there's a general trend in pushing investment law to be more sustainable. However, in the renewable energy cases that I've looked into, I realized that the tribunal has been reluctant to address this issue, and they have simply looked at legitimate expectations from the traditional technocratic way. Here, please allow me to share my slide for a moment. There we go. Can everyone see this? Right. So this is a table that I have put together to kind of dissect how the tribunal has analyzed renewable energy investment cases with relation to the legitimate expectations of investors. So first, it looks at whether general regulation could constitute as specific commitment. And of course, the views were very divergent on that aspect, even though the basic facts were quite similar. For example, in Bolzon versus Italy, the tribunal stated that there is a possibility for the general regulation to be considered as a specific commitment. However, in Charnay versus Spain, the tribunal said that in order to protect public interest, we should not allow such an approach to petrify the state from enacting any regulatory change. And then, even if we don't look at whether general regulation could constitute as specific commitment, the tribunal still seeks to see if there are specific commitment arising beyond general regulation. For example, in the Master case versus Spain, the tribunal decided that certain individual communications, such as posters, presentations, letters that was given by the Spanish government to Masada could constitute as specific commitment that they would not change the feed-in tariff rate. And then beyond that, we can see a return of the stabilization clause in analysis. For instance, in Cube versus Spain, or Norwegian, Ren, and Opera Fund, the tribunal decided that under the general regulation, there was a provision, Article 44.3 of the Royal Decree, that could be construed as a stability assurance that would constitute as a specific commitment for Spain to relinquish its right to change the regulatory framework. And then for some tribunals, they would even take a very broad perspective on what give rise to legitimate expectations and say, even without specific commitment, there could be certain rules that are specifically addressed to a particular investor in order to induce investment that could be construed to give rise to legitimate expectations. For instance, in Narrators versus Czech Republic, in paragraphs 366, the tribunal said that even official documents, official statements without binding force could induce legitimate expectations for the investor. So we could see that there are broad interpretations of what constitute legitimate expectations. However, those points of views come from the BIT itself. It hardly ever looks to the broader implications of international environmental law. And that is not just a theoretical problem that I'm proposing. It has actually been raised by the parties. For example, in Extra versus Spain, the investor claimed that the fair and equitable treatment under ECT should be applied in light of the European Charter commitment to legal stability and the environmental protection goals explicitly identified in the Energy Charter Preamble, Article 2 and Article 19. Of course, Spain disagreed and said that Article 19, which was about promoting energy efficiency and renewable energy investment, is not of relevance and does not mandate the granting of petrified public subsidies, and the ECT respects the state's regulatory power in the area of state aid. And also, the Kyoto Protocol and EU renewable energy directives have also been used by the state, by Spain specifically in Opera Fund versus Spain, as a defense of proportionality, stating that the state is not obligated to over-subsidize the renewable energy enterprise. Instead, it's only protecting the investment so that it would have a competitive status to the traditional fossil fuel investor. Therefore, I believe that it would be beneficial to actually consider the international environmental agreements that could actually support and also promote a holistic interpretation of legitimate expectations. I believe that we could look at the problem from two different perspectives. The first is the normative support. If we look at Article 6 in the Paris Agreement, Article 2, the Preamble, Article 19 of the Energy Charter, and more specifically of domestic law, for instance, the Renewable Energy Directive of the European Union, and then the Spanish Renewable Energy Directives, etc., we could find normative support that actually says that we're supporting renewable energies to fulfill the Paris Agreement goals, to mitigate climate change. And that could provide a legal framework to say that those investors are not pushing to restrict the state's right to regulate. Instead, they are pushing for a certain kind of expectation, for a certain kind of legitimate expectation in this age of clean energy transition. And if we allow certain interpretation, it could also provide the state with a defense mechanism when oil and gas investors say that you cannot change the previous feed-in tariff incentives provided to them before. So that's why I think that there is importance to provide a holistic interpretation to legitimate expectations and to allow a certain kind of incorporation of international environmental agreements into bilateral investor-state arbitration. That would be, am I still on time, Daniel?
You are absolutely perfect, yes.
Okay.
And thank you very, very much for that presentation.
Thank
I
you
see
so
that
much.
you've already attracted a question from the audience. I think we might defer that question for just a moment, but I'll allow you to review it and consider it, because when we start the roundtable discussion, I think I'll ask you to address it straight up front. But a fascinating discussion raises a number of challenges. I know I have some questions, and we will come to those in just a few moments. I would now like, thank you. I would now like to call upon Professor Zhu to take the stage.
Thank you, Daniel. I will share my screen for the slides. Okay, can everybody see the slides?
Yes.
Okay, perfect. Okay. So my presentation is about the structural tension between international investment law and the environmental law. This topic is actually a paper that I'm still developing, and the opinion might not be that mature, so I will welcome any criticism and also any constructive ideas. So for the tension of environmental protection and international investment law, this is not a new topic. Nowadays, there are more than 300 international investment agreements, including bilateral agreements and also multilateral agreements. There are also more than 1,000 ISDS cases, which is between investor and the state. And among those cases, many of them are about the environmental regulation of host states. In those cases, environmental regulation of states are challenged in front of an international investment tribunal because they are claimed to be violated some articles in the investment treaties. So this has caused many environmentalists to worry that there might be a chilling effect on environmental regulation. And there are a bunch of literature already on that. So in order to remedy such a chilling effect, nowadays the IIA reform is more and more focusing on how to allow states to have more regulatory space. There are generally two approaches. One is clarification, the other is carving out. For clarification, it means that the new treaty tries to clarify certain standards of protection clauses. For example, try to equate FET clause to the MST, the minimum standard of treatment in customary international law, or in the national treatment or most favored nation treatment clauses, the new treaties try to clarify what is in like circumstances. Another approach is carving out. This is basically realized by a justification approach, which means if the state can justify that its environmental regulatory measure can achieve certain goals, including environmental goal, it then can be carved out from a violation of investment protection standard. One example is the indirect expropriation clause. So there are some special exception to indirect expropriation clause, meaning that except in rare circumstances, environmental protection measures will not be regarded as indirect expropriation if it can meet certain standards. Another example is general exceptions clause. This is borrowed from the WTO rules, and it lists several exceptions, for example, environmental protection exceptions, and those exceptions will apply to all the clauses in the treaty. So the current literature basically does not put a lot of emphasis on a distinction between the two methods. In my research, I try to differentiate two kinds of tensions. One is normative tension, one is structural tension. So I will explain later what is normative tension and what is structural tension in my paper. So for normative tension, I think the justification method, which tries to prove the means-end relationship, will be okay, but this method will not be appropriate to solve the structural tension, in which case a clarification method is better. So for normative tension, actually, most people talk about the tension between environmental law and international investment law in this sense. There is a tension between the different objectives of investment protection and environmental protection. For example, international investment law is made to protect the foreign investment and to promote capital flows globally. But environmental law is made to protect the environment. So the basic tension is the competing objectives of the two, especially when the government tries to balance the two objectives. For example, so a basic principle in environmental law is the polluter pays principle. It requires the investment to it requires the polluting investment to pay for what it has polluted. But investment law normally protect the foreign investment. So, for example, in the expropriation clause, even if the country expropriate the investor for public purpose, such as for environmental purpose, the government needs to compensate the foreign investor. And when the government just makes some regulatory measures, which is not direct expropriation, but indirect expropriation, it also needs to compensate the foreign investor. So this has resulted a tension between the polluter pays principle and expropriation. This tension also happens in polluter pays principle and non-discrimination, because traditionally, the foreign investment law requires a non-discriminatory treatment between different investors. But such non-discrimination assessment only considers whether the two investors are in the same sector. This is the traditional approach. So it often neglects whether the two investors cause different levels of pollution. So there is a tension between the two competing objectives. So for such tension, a justification method is okay. The tribunal can allow the whole state to prove whether your environmental measure can achieve or is necessary to achieve the environmental goal. If it is so, then such measure can be justified. This is the logic behind some justification methods in the II reform. For example, the general exceptions clause. It normally provides that if the country can prove the measure is necessary or is related to environmental purposes, then it can be justified. In my paper, I try to prove that there's another kind of tension called structural tension. The structural tension does not arise from the competing policy objectives, but from the different governance structures of the two legal regimes, international investment law and environmental law. I argue that international investment law requires a consistent, stable, and predictable legal framework regulating foreign investment. But environmental governance is often decentralized, cross-sectored, and constantly evolving. So there is a distinction between the structural governance of the two legal regimes. There are some examples for the structural tension. For example, environmental law encourages the bottom-up environmental governance because only local people know the local situation, and many environmental problems affect the local people significantly. So there might be different environmental regulations between the local level and the federal level, or between the state level and the federal level. But such bottom-up environmental governance may cause a violation of international investment law. For example, in metalclad case, the different environmental regulation in the local level and the state and federal level has been claimed as a violation of the FET standard. And also in the Merrill and Ring versus Canada case, the different environmental standard in state level and the federal level has been claimed as a discrimination. Another example is that environmental standard is often designed for a particular region or zone. This is called the test zone. Sometimes the state will apply the new environmental standard first to a particular zone rather than applying it to the whole country at once. This is an example in the Urey-Bogdanov case. In this case, the Moldova has applied a special environmental standard to a special economic zone only. So the investor argued that it has been discriminated against compared to those investors outside the zone. A third example is that there are usually multiple governmental authorities involved in environmental regulation. Normally, for some environmental licenses, there are not only the environmental government branches involved, but also some other sectors. So, for example, the economic sectors or commercial sectors. And in those cases, different sectors may make different judges based on a check and balance. But this may violate international investment law. For example, the inconsistent decisions may violate the FET principle, and also the different jurisdictional authorities may cause difficulties for the non-discrimination assessment. A fourth example is a cross-sector environmental governance. Some environmental problems does not only happen in one jurisdiction, but it may happen in different jurisdictions, different provinces in one country. So one environmental measure may be applied to different provinces and even to different economic sectors. On the other hand, maybe in one economic sector, there are different environmental standards be applied to different investors due to their pollution levels. So this has caused difficulty for the non-discrimination standard. For example, in the Buchan versus Canada case, there's difficulty for tribunals to decide whether it should apply the same whether the different sectors of investments can be comparable under the same environmental measure. And there's another case, Arcelor versus France case. This is not an investment law case, but it's an ECJ case. It is about that the environmental measure, the ETS is applied to different sectors, not only the steel sector, but also polluting sectors. So whether those different sectors can be comparable under the same measure, this is also a question for the assessment for non-discrimination. So I argue that for the structural tension, the justification method is not appropriate because it is hard to prove the means and ends relationship. For example, how to prove that the decentralization of environmental governance is necessary or is related to the protection of environment. This is especially the case because environmental federalism is by itself a hot topic under discussion in environmental law. So whether the environmental governance structure is just, it is a very difficult question to answer. For another example, how to prove the inconsistent regulatory acts between environmental organ and other state organs are directed or necessary to protect the environment. This means and end relationship is also very hard to prove. A better approach, I argue that, is the clarification of standards of protection with a deference to the character of environmental governance structure. So it's better to clarify those standards of protection in investment treaties with a deference to the character, especially the decentralization character of environmental governance. Then I assess the current IA reform to see whether there are enough regulatory space for the structural tension. Unfortunately, I found that most treaties use the justification method. For example, you can see in 1980s, the prohibitions and the restriction provision, it requires the measures is directed to the protection of some essential security interest or the protection of public health or some other public interest. And after 2000, the general exceptions clause require non-discrimination requirements, but the expression is also that the measure should be directed to the protection of public interest. So if you require the country to prove that their decentralized environmental governance system is directed to or is necessary for environmental protection, this is actually very hard for the whole state to justify its environmental governance. For the clarification method, I found that actually a small proportion of IA treaty reform adopt this method. And they adopt various methods among treaties, and only a few of them reconcile the structural tension. For example, you can compare the two different ways for the clarification. On this side, it is better to reconcile the structural tension because it not only requires the measure has a means and end relationship with the goal, but it tries to clarify what is in like circumstances by pointing out several elements to consider, including the structure of the regulation. For example, the sector the investor is in and the regulatory process generally applied in relation to the measure concerned. Another example is the clarification of FET. So if broadly linking the FET with the MST in customer international law, it might not be very good because this does not consider the structural tension. It is hard to prove that. But another approach is to specify in the treaty an exhaustive or indicative list of FET elements, and by this way, the reformers can incorporate the structural tension concerns in the specification of the FET. So my conclusion is that actually there are two kinds of tensions between international investment and environmental law. One is normative tension, the other is structural tension. And the commonly adopted justification method in literature and treaty practice can justify only the normative tension by proving the linkage between means and ends, while the structural tension can only be reconciled by the clarification of investment protection standard with a deference to the character of environmental governance structure. By an empirical study, I see that the ongoing reform of IAs mainly adopt the justification approach, which makes it weak to reconcile structural tension. So it is proposed that future IAs should combine justification and clarification method to have a due regard to the normative and structural tension. So this is the end of my presentation, and I hope you could help me to refine my paper. Thank you so much. Bye-bye.
Thank you very much, Professor Zhu. There's a number of questions beginning to crystallize in my mind about not only how we manage these challenging issues going forward with new investment treaties, but also what we do about the existing texts. But before we get to these questions, and I also direct you to the public chat where there's been a little bit of active discussion on this, I'd like to turn the stage over to Dr. Joan to present your arguments and position.
Respected moderator, Mr. Hohnstein, my fellow panelists, and the attendees. Warm greetings from India to everyone. It's indeed an honor for me to present my paper titled International Investments in Natural Resources, Some Governance Concerns from a Developing Country Perspective before you. And I thank the Society of International Economic Laws and the University of Bocconi, Italy for this invaluable opportunity. My paper evaluates the significance of balancing the interest of the host state and the interest of the foreign investor for a better governance in investments in natural resources, a sector which is very special as there are many environmental as well as public policy concerns. If you look at the history of international investments in natural resources, we could see that the tension between developing states' interest in controlling and governing their natural resources and the multinational companies' interest in having full access to the resources was resulted in the birth of the principle of permanent sovereignty over natural resources in the 1960s. And one of the major consequences was that of nationalization of foreign companies in the oil sector. International investment rulemaking for the protection of natural resources was a major concern for many states as policies not leading to economic growth or not tackling corruption, defective organization, loss of economies of scale, inefficiency, and many other flaws are causes of violation of rights directly attributable to public authorities. The increased attention to environmental law principles in the 1990s and the active involvement of local population or the affected parties thrust to redefine the regulatory space, including a space for contestation and negotiation involving a wider range of public and private actors influencing the decision-making process. For over 10 years, investment dispute settlement related issues have been debated with increased intensity by the international investment and development community, and in recent years, discussions have reached the highest levels of government. For example, countries including Brazil, India, South Africa have significantly rethought their approach to investment protection, leading to many policy innovations. Brazil follows a model of signing cooperation and facilitation investment agreements, which have no mention of protection of investments or ISDS system. References can be made to the Angola-Brazil Investment Facilitation and Cooperation Agreement 2015 and the Brazil-Mozambique Investment Facilitation and Cooperation Agreement 2015. India's new model BIT provides for exhaustion of local remedies for a period of 5 years. The South African initiative completely relies on mediation rather than ISDS. Bolivia, Ecuador, Venezuela, Indonesia are also attempting to disengage the traditional bonds of BITs and ISDS regime. Initiatives like inclusion of sustainable development goals, as in Cameroon, Canada BIT 2014, inclusion of provisions modeled on Article 20 GATT, the general exception for the protection of national security, public morals, human, animal, or plant health, plant life or health, and environmental protection are in a rise. Article 22(1) of Common Market for Eastern and Southern Africa Investment Agreement 2007, Article 17 of ASEAN Comprehensive Investment Agreement 2009, and Article 20 of Benin-Canada BIT 2013 are some examples. The narrowing down of investment protection clauses, as in India Model BIT 2016, Rwanda-US BIT 2008, ASEAN-Australia-New Zealand FTA 2009 are also notable in this context. The reasons behind these new approaches by developing states include unpredictability of arbitral proceedings against the state, as there is a possibility of claims by unknown and large number of investors under the ISDS, and the pressure to strengthen administrative and judicial facilities, as many developing states face capacity challenges due to poor resources. Whenever it comes to international investment in natural resources, it could raise sensitive political issues as it affects control over strategic and emotive assets closely connected to social and national identity. Lack of transparency in investment treaty negotiations and asymmetries in access to information between business and advocacy groups, and lack of awareness about international investment law are significant issues in developing states. A good governance model taking care of all stakeholders is necessary. Discussions among activists, academicians, policymakers, judges, and also in all spheres of society shall be promoted to ensure sustainable economic development, reconciling development needs with environmental protection. Further, challenges as to the interpretation of investment standards shall be taken care of, and the state's duty to protect from violations of human rights shall not be disregarded by expansive interpretations of investor rights. The regulatory space available to states in international investment rulemaking must be adequate enough to take care of environmental concerns, and claims of investors for general legislative changes affecting the entire population shall not be enabled. Identification of public interest exception by the tribunals in Parkerings versus Lithuania, Antoine Goetz versus Burundi, Glamis Gold Limited versus the United States of America are worth mentioning here. I also argue for the home state obligations for environmental damage and the use of non-precluded measures in BITs. The recognition of the liability of the foreign company in the home state for the damage caused in the territory of the host state by the Hague District Court in Akpan decision, by the UK High Court in Bodo Community decision are indeed pointing to the significance of natural resources conservation in international investment jurisprudence. Non-precluded measures provisions are now relatively common in the BITs of Germany, India and the United States. For example, 2021 US model BIT states that investment should not be encouraged at the cost of reducing domestic standards relating to labor and environmental protection. In case of NPM clauses, there is balance between right to regulate and investor protection, as the investment tribunals will be deciding whether a measure can be allowed under an NPM clause or not. I conclude with the note that balancing the investments with nature conservation is very important for a sustainable future, and it places a very high responsibility on states to be mindful of the interest of all stakeholders while making policies for economic development. And this obligation shall be respected by the international community while making international rulemaking in international investments. Thank you.
Thank you very much, Dr. Joan. Wonderful presentations, each of you. I'm hoping that we can dig into each of your positions and your arguments a little bit more during the discussion. The discussion will be broken into two stages. The first stage will focus on discussion between the panelists as they test each other's arguments. And after about 10 to 15 minutes, we will open the floor to questions from the audience. In the meantime, in the process of having your discussion, panelists, I encourage you to keep an eye on the public chat and feel free to address any issues that are raised there. In order to kick things off, a question in my mind is, what do we do about existing treaty texts? And I know that a couple of ideas have been raised here, and I'd like you to discuss that. It seems clear to me that there's room for change going forward as we draft new agreements and as old international investment treaties are updated and reformed. But what do we do about the existing texts that stand and the old regime of rules? What are the mechanisms that might be available to build in these environmental climate change concerns when resolving ISDS claims? Who would like to take that on first?
Thank you, Mr. Hohnstein. Yeah, I think that question connects very much to Dr. Giama's question for me and Professor Drew. For me, I take the perception that we should definitely try to have the arbitrators take a more holistic approach to certain interpretations. And that, of course, goes back to saying that just a systemic integration method is not enough. That's why I'm currently writing the theoretical framework part of my thesis, which I kind of look to global constitutionalism to find whether there is a way to create a certain kind of normos and narrative. I've recently been very fascinated by the very famous work by Robert Cover, which talks about redemptification under racism, to attack racism back in the 1980s for the US Constitution. And the way he sees it is we need to have redemptive narrative to make sure that certain concerns are given priority. And I do believe that's currently what's needed. I'm not saying that I'm granting a certain kind of superior hierarchy to international environmental law, because that's not my place to do. But I felt with the flexibility that is granted to arbitration, there is a certain kind of possibility, practical possibility to integrate concerns into legitimate expectations, particularly when that concept have rarely, almost never been defined clearly in BIT itself. So that's my interpretation. I felt like there's a need to clarify, as Professor Drew says, and there's a need to renegotiate and redraft those treaties, but those take a long time and at a high cost for developing countries. So I also think that the arbitrators should also take on the responsibility and see themselves as the forefront runners that could actually promote sustainable development. Thank you so much.
I take the second spot. So Actually, I think this is a very good, but very important issue because actually, for new treaties to take into force, even if it is negotiated and signed today, it may take into force in 10 to 15 years because the old treaty still protects investors for a period after the end of the treaty. So this is a mechanism for protecting the third-party beneficiary in the treaty. In this case, is the foreign investors. So the foreign investors normally can still use the old treaty to protect themselves even after the negotiation and signature of the new treaty. And this is happening in reality. For example, the XII, the Comprehensive Agreement on Investment between China and Europe. Also, the XII has very pronounced and developed a chapter on protection of public interest, including environmental protection, human rights protection, labor rights protection. But it is built based on more than 20 investment treaties between China and European countries. So those treaties will still be in force even after the XII is concluded. If the XII will be concluded, because now it is going through some obstacles in Europe now. So this will make reforming the adjudication more important. And actually, I think the incorporating environmental concerns in investment adjudication has been a trend, and more tribunals has the sense to incorporate environmental concerns when adjudicating several standards of protection, including non-discrimination, fair and equitable treatment, or indirect expropriation. This is not uncommon now. The problem now is the inconsistency between the tribunals about how to conclude those, how to incorporate those environmental concerns. How should we interpret in like circumstances? What elements should we consider? What is indirect expropriation? How to distinguish indirect expropriation from environmental, the compensable expropriation, also for environmental purposes. So those are the questions tribunals are trying to deal with. And the inconsistency is resulted from the deep roots that the system itself is scattered. The tribunals do not have a permanent appellate body to have a consistent precedent to follow. So I see this is a very important question and very important issue faced by our reform of international investment law. But on the other hand, this is a difficult issue to handle because of the complexity of the situation, especially because of the procedural aspect of the international investment adjudication system. Thank you.
If I may add upon. So I would like to continue from the discussions given by my fellow panelists. And I would like to, speak with respect to two main points. So the first point would be that of who shall be the arbitrator. So of course, there has been this particular debate all throughout. Okay, who can be the arbitrator in an international investment dispute settlement? Okay, whether private arbitrators, commercial arbitrators could decide upon issues of public interest. That was very much being criticized, private arbitrators deciding upon public issues. And now there has been this particular trend that public international law experts who are having some experience in commercial matters getting appointed as arbitrators. So, now we can expect that, okay, all these issues may be considered holistically. And, people who are having experience in public international law, they would definitely give, relevance to these human rights issues and public interest issues and, other issues which are affecting the public at large. That is one of my observations. And secondly, with respect to the inconsistency, okay. So of course, okay, there is no precedential value for okay, these decisions. Each and every dispute is separate, and the facts are different. All these are true, but at the same time, there is no bar for looking at the previous decisions for the purpose of understanding certain interpretation of certain provisions or principles. So the development of probably a de facto precedent in international investment law jurisprudence that would bring more clarity and again certainty, and to certain level this uniformity and certainty is needed, and if this is accepted, it will take some time, then it can do wonders. This is what I believe. Thank you.
Okay, thank you very much. I have one last question that addresses a question that's been raised in the public chat, and then I would encourage a free-form discussion. And it's an interesting point that it hadn't occurred to me before, but it is an important jurisdictional procedural point. You mentioned the role of arbitrators in moving this forward. And my question for you is, what's the best approach? Should arbitrators have any capacity to look at environmental climate change obligations in their own initiative? Or for the purposes of jurisdiction, is this really something that a government has to raise as a defense? And what are your reactions to that? Dr. Joan, you're on mute.
Am I audible right now?
Yes, we can hear you now.
Yes, thank you. If I quickly react to that, okay, there is this particular aspect that okay, we should take care of. Okay, could you please repeat the question once again?
My question is it outside of a tribunal's jurisdiction to consider environmental obligations, international obligations, and even domestic environmental regulations and laws that might be relevant if the government doesn't actually raise them as a defense?
Yes, thank you so much, Mr. Hohnstein. Actually, there are a lot of discussions about the interaction of international law and international investment law. So, of course, for the purpose of determining the applicable law in international investment arbitration, there are a lot of discussions about the applicability of national law, the applicability of international law, and the combined application of international law and domestic law. Okay, so with respect to environmental protections and all, there are so many soft law instruments as well as hard law instruments, and it is the obligation of state parties to incorporate it as part of the domestic legal system for the purpose of having applicability to it. So basically, whenever it comes to applicable law in international investment law, of course, there is a possibility for arbitrators to identify the source of law or the potential source of law as international law. And whenever the potential source of international law, it is also possible to look into the aspects of domestic law because of this particular interaction between international law and domestic law. Okay, so these interactions, they are inevitable, and again, international environmental concerns as well as investment concerns are interdependable. Okay, some tribunals were of the view that they are not interdependable, but of course, okay, there are some jurisprudence showing that interdependency of international environmental concerns as well as international investment concerns. So this interaction could be given effect, and I think there won't be much problem for the arbitrators to look at this particular interaction for deciding applicable law. Definitely that will give jurisdiction.
Reactions from the other panelists?
Professor Joan, I completely agree with your approach, especially when you talked about the investor should also kind of adhere to the home state's obligations in environmental law during your presentation. But I do have a question when I think about it, because I recently was talking to some practitioners, and they brought up the question of, if in a civil law country, is the arbitrators still required as a requirement to look into the case law of environmental regulation, for example? And I don't really have a question for that. And for me, I felt like if it's a common law system, of course, then it's a part of the law, and you should definitely look at how domestic law have evolved and how the verdicts have been by domestic courts. But in a civil law country, does the arbitrators have the flexibility to overlook certain trends in domestic tribunals, the trends for promoting sustainable development, and still make a decision to ignore those current trends that doesn't really have a binding precedent value in civil law countries? So that's just some thoughts. I hope I'm not rambling on. Thanks.
So I would like to react to it by this particular question raised all throughout the jurisprudence. Is there a common law system of precedent in international investment law? Or maybe is there a common law system of international investment law? These are the titles which I had gone through regarding these discussions. So of course, at the end of the debate, I have understood that, okay, there is no de jure system of international investment. So it is, that is with respect to international investment decisions per se. And with respect to this particular question, whether the tribunal should look into the trends which are followed by the domestic courts, okay. So, of course, in international law, or maybe if you look at the jurisprudence of International Court of Justice, we could see that, okay, it is not, there is no persuasive effect of these decisions on the arbitrator, but at the same time, the arbitrator could grab certain points from all these decisions. So, it's not necessary, it is not persuasive that, okay, the arbitrator to follow that particular viewpoints. But, I think that there is, nothing wrong, the arbitrator, if he is interested in looking at the practices that are followed by the domestic judiciary and so on. And again, another aspect, it is quite possible in international investment arbitration that the flows in domestic legal system that could also give rise to certain challenges. So, of course, the domestic legal system is under the scrutiny of international arbitration generally. And again, the activity, the decisions, the points that are scrutinized by the international arbitrators or the, or the community of international investment lawyers as a whole. So domestic legal system has this particular pressure to improve upon their own decisions. And again, to show that, okay, they are having these concerns. And again, okay, these are the reasons why, they are following these particular practices and giving justifiable reasons as part of their, decisions. So once that is given and the arbitrator is looking at it and grabbing certain points, I think it's, it's perfect for the protection of natural resources, or maybe for incorporating the environmental concerns as part of international investment jurisprudence.
Oh, great. So I think the relationship between domestic law and international investment law has been a key issue. And there are some literature already on this. What's the extent of domestic law the tribunal should resort to? And if we think it deeper, actually this is even a key question for the whole system. The relationship between domestic law and international investment law. And sometimes if we consider the reform of ISDS regime, this can also predict where we want the international investment law go to, because in the current WTO appellate body crisis, one criticism against the appellate body is that it has too much power to review the domestic law of the state. And the appellate body should only review the law, not the fact. But is domestic law a fact or it is a law? So it is hard to decide, but this can be a criticism against the appellate body of the WTO. And if we design a new international investment law adjudication system, this might also be a question that should be considered by us. And on the environmental issue, actually, in most cases, it's the domestic environmental measure that is challenged. But in some cases, the domestic environmental measure can be justified by its compliance with international environmental treaties. And for a few cases, those domestic measures are directly made to implement international environmental agreements. So how to deal with such situation? In some investment treaties, there are explicit conflict clauses to solve this problem. For example, Article 104 in NAFTA, it explicitly pointed out some environmental treaties and say that if there is conflict between those environmental treaties and NAFTA, then those environmental treaties will prevail. But if there's no such conflict clause in the treaties, which is most the case, how the tribunals will deal with that. So for some tribunals, they follow the VCLT Article 31 on the systematic interpretation. They will, in some cases, the tribunals hold that actually we will take an systematic interpretation, and we think that the environmental agreements between the two parties are relevant to both parties. So we'll consider that situation. So this is the case in the case of SD-MEAS. In that case, the tribunal did consider the agreement between the two parties. But in other cases, it also happened that the tribunal did not take into account of that treaty. But this is a special situation when the treaty is signed between the host state and the home state of investor. But in some cases, there's also a situation that the environmental treaty is only signed by the host state. The home state of the investor is not a party to that treaty. So will that treaty be relevant for the systematic interpretation in Article 31 of VCLT? This will be a question. So in Chamtra case, the tribunal have take account of such treaty as a provement, to prove that the country did adopt the environmental measure for good faith. So it's just a proof of good faith. But in other treaties, in other cases, the tribunal even did not take into account such treaty. So this is a very complicated question, and the tribunals have taken inconsistent approaches to deal with the implementation of international environmental obligations. So I hope this might answer the question.
So Hohnstein, is it okay if I jump on Professor Zhu's point?
Absolutely, yes. Please feel free. And going forward, no one has to sort of clear that. Just jump straight in. Let's have a fluid discussion. Just before you proceed, I'd just like to let the audience know that the Q&A function is now live. If you would like to ask a live question by video conference, please make your request. And the only protocol that we'd ask is that before asking your question or providing your comment, you introduce yourself. And we look forward to receiving your questions. With apologies for that interruption, please proceed.
Thank you. Yeah, I want to kind of jump on Professor Zhu's point because I think we share some of the common understanding, like in the SD-MEAS case, how the US didn't actually ratify the treaty, but then the state, like the tribunal still said that we're going to proceed to analyze this case as if the US had ratified. And even in that case, this Basel Convention would still not be applicable because we need to apply the least trade restrictive measure. And that's why in SD Myers, it was like heavily criticized later on by environmental groups. And also Professor Drew mentioned another point about how if we look at how domestic law has incorporated and justified international environmental agreements, we might want to look into the Burlington case and the Parento case, again, the counterclaims that was raised by Ecuador that actually said, for instance, they referred constantly back to the Ecuador constitution, and they said that they try to implement international environmental principles from the Biodiversity Convention, and also try to make sure that the principle of environmental protection is enshrined in their constitution. And even in that case, the tribunal decided that they should not use that as a benchmark to decide the compensation which the investor should pay. So on some level, I'm a little frustrated of how the tribunal has interpreted those incorporation. And it felt to me that even though in certain cases where domestic law is reacting to international environmental obligations, the tribunal does have a certain kind of flexibility to ignore that and to like take a different way and decide we're not going to touch upon those issues because it's constitutional law and it doesn't really have an effect in this case. And also, if we can look at like there was a different case where they actually talked about compensation, and I'm a little confused of why fair and equitable treatment nowadays is on the same level of compensation with indirect expropriation. For somehow I always felt like as an intuition that environmental conflicts and environmental like measures adopted for environmental purposes, even if they do breach fair and equitable treatment, should that payment be calculated in the same DFC approach as the way we do in indirect expropriation? I felt that kind of, to me, it feels like an overstretch, but would love to hear your opinion on, and also from Professor Joan. Thank you.
Yes. Actually, I was replying to the question in the chat box. So I think, and I got this particular reply that the answer is clear. So if there is anything else, I'm very happy to answer.
Go ahead, Professor Zhu.
Should I go to the Q&A part, or should I follow on our Dr. Pang's question?
Answer the Q&A. Like we can talk individually later on.
Yeah, exactly. Yeah. Please feel free.
Okay. Yeah, so actually this is, I think Dr. Pang has raised a really interesting point, because expropriation might be a special case compared with other standards, such as fair and equitable treatment or non-discrimination, such as NT or MFN. So for expropriation, even legitimate expropriation require compensation. But if you but for other clauses, only if you are unfair, unjust, or if you discriminate, you do some wrong things, then you have to compensate. So this might be two different systems. This might be why scholars are still struggling about whether indirect expropriation should generate compensation and how to distinguish between indirect expropriation and legitimate regulatory measures. So some scholars argue that legitimate expropriation require compensation. So why indirect expropriation for legitimate purpose will not generate compensation? But other scholars will argue that if we require compensation for indirect expropriation, that may cause a very heavy burden for the whole state, because many regulations might be claimed as indirect expropriation. So I think this is very important question, and I personally do not have a clear clue on how to answer it. But I think it is a particular question. Should be a particular distinction between expropriation and other clauses regarding compensation. And for the questions, I see a lot of questions. Maybe I will try to answer some. I will just scroll the chat box. Actually, there is a suggestion about public participation. Public participation, yes, I think it can be a strong argument supporting the fragmentation in the decision process of environmental regulation. So environmental regulatory decision process might be different from other areas because it does not only include the governmental officials who will decide the case. It will also required to involve public to express their own opinions. And there are already some cases in international investment adjudication about public participation. For example, in the Parkering's case, in this case, it's about building a parking lot near the old town of the city. The old town is a protected area, and such construction has been subject to the strong public opposition, and the tribunal needs to decide whether the public opposition can be a factor that the government should consider when deciding the distinction between this foreign investor and other foreign investors. This is one case. Another case is the Buchan versus Canada. In this case, the construction project also suffers the public opposition because it is built on the seaside, and it will interfere with the maritime activities. So it is also subject to the local opposition, and the Canada did took into account of the common core interest of the local population to decide whether whether to reject the construction of the project. So there are some cases involving the public opposition, and I do think that this should be something the tribunals should consider. And it is also why the environmental governance is different from other kinds of regulatory products. And I see there are also questions about the fragmentation of the treaties. Yes, nowadays the treaties are fragmented, and even if the general framework of the international investment law is basically similar between different treaties, but there are slight differences. For example, about what is national treatment. Some treaties have qualified national treatment, which means the national treatment should be subject to domestic laws and regulations, and other treaties has non-qualified national treatment. So there are different provisions in different treaties, and this kind of caused the fragmentation of the international investment law system. But I do think that the tribunals should adhere to the language, the explicit language of those treaties, instead of trying to find a coherent interpretation among all the treaties. I think the textual interpretation should be the first. If the texts are the same, then we are trying to find some coherent interpretation. But if the text is different between the treaties, I think the foremost interpretation method in the BCLT should be followed, even if this might cause some fragmentation between the treaties. Then I will look more at questions, and then please answer your own questions.
Dr. Rosmy and Ms. Pang, any reactions to Professor Zhu's points or any of the questions that have been directed specifically to you?
Right. So I think I would first answer Dr. Giesma's question about current trends in treaty drafting and whether the tribunal will be bound by the old way. I was actually writing a reply in the chat. I think I completely agree with this concern, and actually that was one of the points that I kind of raised in my presentation, because I felt that the tribunal is kind of bound to technocratic interpretations, and I was hoping that we could move away from that and to have a holistic interpretation. But I do think there are certain tools, like even though that nowadays there have been backlash against the ISDS system, but if, for example, there are normative support for moving in a more sustainable direction. For example, if we look at the articles for setting up XII and we look at the documents that the World Bank issued to the states who were signing up for ISDS, we could see that the World Bank actually used the word development rather than economic development. So it wasn't exactly just a very brutal or very blunt economic liberalization purpose to set up BITs. They had the broader view to develop the developing world, to promote social welfare. So if the tribunal or the arbitrators were willing to move into that direction, they could find certain normative support for that interpretation. And I do think that there is room to wiggle there. And so that's the question from Dr. Giesma. And I think I answered his second question about the effective connection between IIAs and environmental treaties by referring to global constitutionalism, although I'm still developing that idea. Please feel free to email me, or I'll email you and we can have a discussion about how we could develop this theory further. And I think there is another question from Dr. Rosmy. I'm so sorry if I'm pronouncing your name wrong, about how we should restrict legitimate expectations. And I think that is a question that is really important. And I do think that we're experiencing a lot of pushbacks in that area when we're redrafting IIAs, because even though the ancestral reforms are currently going forward, but please correct me if I'm wrong from my fellow panelists, the way I understand it is it's still focused very much on the procedural problems, and it doesn't really want to touch upon very substantive matters, even though the member states are submitting their understanding on substantive provisions. But the working group was initially set up to address procedural concerns. So in that sense, I'm a little concerned of how we could clarify those terms going forward without having the developing states to go over renegotiating like what India is doing, having to terminate all the previous BITs and to renegotiate them again, because it would be quite burdensome for smaller states to do that. I think we lost Professor Zhu, unfortunately. Yeah, and like for big economies like China, India, Brazil, we might have the kind of economic power to do something like this. But if you think of Ecuador, Uruguay, and Costa Rica, for example, would they be able to have that political resource to actually terminate all the current BITs and renegotiate again? So I think that's a concern that I don't actually have an answer to, but thank you so much for proposing that question. I think it's a question that all international investment lawyers are seeking. Thank you.
So if I may reply to some of the questions. So I'm seeing this question by Varindran Vamsiri. I'm so sorry if I'm pronouncing wrong. So regarding the balancing exercise, okay, to what extent the environmental concerns to be valuable enough? So if you could look at some of the cases in international investment law, we could see that, for example, I would like to cite upon maybe Parkerings versus Lithuania, or maybe Antoine Godes versus Burundi. So we could see that, okay, the risk on part of the state to show that these initiatives were necessary in the interest of environmental protection, that was not at a very high level. Okay, so that is also like a welcome approach. So if this type of interpretations for the purpose of giving emphasis upon environmental concerns, that the measure was reasonable enough. So what are the standards to be taken care of, or maybe what are the standards to be considered for the purpose of determining whether this particular measure was appropriate or not? So it can be reasonable standards, and standards may be of a lower level. And sometimes it is really good that, okay, even the lower level standards are getting appreciated for the purpose of balancing the environmental interest with economic interest. Because, the sustainable development, the concept of sustainable development itself, focuses or specifies on this particular aspect, the development without taking care of economic, social, and environmental aspects, that cannot be called as sustainable development. So it is necessary to give weightage to economic, social, as well as developmental concerns to the equally to the extent possible. That is my reaction to that particular question. And again, with respect to the regulatory measures, what type of regulatory measures should not fall within the scope of investment treaties, and how there can be a reform with respect to environmental clauses and so on. So recently I had gone through some of the literature. It was talking about probably modeling the international investment rulemaking on international investment law principles, because all these disciplines are evolving. And if we have specified principles and specified standards already in existence, it is really good that, okay, focusing on those standards to the extent that could be incorporated as part of international investment rulemaking. So maybe we can say that in comparison with international environmental law, international investment law is still evolving. So as international environmental law principles are more advanced and more concretely put on table, so it is possible that, okay, there can be international best practices incorporating these standards for the further evolution of international investment law. So that is basically the practice we are seeing. Okay, there are model bilateral investment treaties coming up with modeled on Article 20 general exception, and again giving priority to environmental concerns, labor concerns. So that is again another aspect. Bilaterally, if states are willing to do that between the states concerned, so for the protection of reciprocal protection and promotion of their investments with a view to protect the environment also, they can incorporate such provisions as part of their bilateral investment treaties also.
Thank you, Dr. Rosmy. Joan, I see that we have 3 minutes remaining in our time available. Unfortunately, we've lost Professor Zhu due to technical difficulties. I would like to give the panelists, each of you who remain, an opportunity for a final comment in 1 minute or less. Let's start with Ms. Pang.
Thank you so much, Mr. Hohnstein. This has been such an interesting panel, and I'm really sorry if I was the one who posed several questions and kind of bombarded my panelists. But I find this to be a really interesting panel, and it's not very common to be put into a panel where we work on such similar stuff. So I was very excited, and I just want to thank the audience for their interesting questions. And I'm going to type my email in the chat function. So if we would like to communicate offline, please feel free to email me. I would love to talk to people about this area. Thank you so much.
Yeah, I found the panel very much interesting, and of course I got this wonderful opportunity to share the views and to learn from others. So I would like to specify on this particular suggestion of counterclaims in terms of environmental protection. That's indeed a very wonderful idea. Still, we have to see how these counterclaims work in the future. But okay, there can be counterclaims for the purpose of environmental protection. It's indeed a great idea. That's a very good learning point for me. And thank you, Helen Pang, for bringing this particular observation. And I thank all the participants, for their interesting questions. And again, I thank Professor Su for bringing this very basic question, the tensions between international environmental law as well as international investment law. So, many questions will be left unanswered, but still, this is a very good starting point for all of us to think and, find something that could adequately give solutions to all these issues, so that probably we could come up with nice solutions in the future. And I really would like to thank the moderator, Dan Hohnstein, for his invaluable support and moderating nicely and arranging everything so nicely. So we didn't have any tension, as we already had a practice session. So thank you so much for all this, and hope to be in touch. Probably we can share our views and researches, so that we can be in touch, and that will definitely give rise to some new scholarship probably in the future. Thank you.
Thank you, Dr. Joan. Professor Zhu, it's great to see you back. Final comments.
Thank you, Daniel. Thank you, everyone. Sorry, apologize for my technical problem. Now I'm online now. So thank you, everyone, for the excellent speech. And I think we have not only listened to excellent presentation by Helen and by Rosmy, but also we had a very interesting and hot debate between ourselves, discussion between ourselves on the important issue. And thank you very much for Daniel for the preparation of this panel, and also for your excellent moderation. And thank you all for listening to us. And because my actually my presentation topic is still developing, so I will welcome everyone to have criticism, or if you have any suggestions, please don't hesitate to write to me. I will be very grateful. And thank you very much for the questions you have already raised.
Thank you so much. Thank you to the panelists, all of you individually and collectively. This was an excellent discussion. I would also like to thank SIEL and Marcus Wagner for their great work in organizing the conference. It's been a privilege to be your moderator, and I wish everybody an excellent day. Thank you.
Thank you
so much.
Thank you.